If you are thinking about divorce, the first question everyone asks is, do I even have a ground to file? But here's the truth that most people don't realize. You cannot file for divorce in Singapore simply because you're unhappy or because the marriage isn't working. The law requires you to prove that the marriage has irretrievably broken down, and there are only 6 specific legal ways to do that. At each one, adultery, unreasonable behavior, 3-year separation, 4-year separation, desertion, or even mutual agreement comes with their own rules, pitfalls, and consequences that can shape the entire outcome of your case, from timelines to finances to the emotional toll of the process. In this video, I'm going to break down each of these grounds clearly, practically, and in plain English, so you know exactly where you stand, what evidence you need, and which path is the safest for your situation. Now let's get started. Before we even talk about grounds for divorce, there are 2 basic requirements. First, you must have been married for at least 3 years. There are exceptions, but they require exceptional hardship or depravity, and they are rarely granted. Second, either you or your spouse must be domiciled in Singapore, or you must have lived here for the last 3 years. After that, the law requires you to show that the marriage has irretrievably broken down. You can't simply say that the relationship failed or that you no longer get along. The court needs to see at least one of 6 legal grounds as set out in the Women's Charter, which I will now go through below. The law recognizes 6 ways to prove the marriage has broken down. 1. Adultery, and you find it intolerable to live with your spouse. 2. Unreasonable behavior, meaning your spouse has behaved in a way that makes continuing the marriage unreasonable. 3. Desertion for at least 2 years. 4. Separation for 3 years with consent. 5. Separation for 4 years without consent. 6. Divorce by mutual agreement. Adultery and unreasonable behavior are fault-based. The others are based on the passage of time and the reality that the marriage is over. More couples today are relying on either the separation ground or mutual agreement ground because they are often cleaner, less confrontational, and much easier to prove. Now, let's explore the first ground, adultery. Adultery is a powerful but difficult ground to prove. You must show 2 things. First, the adultery occurred, and second, you find it intolerable to continue living with your spouse. The court needs proper evidence, not just mere suspicion. This could be in the form of messages, emails, hotel receipts, credit card statements, photos, videos, or even an admission from your spouse. An admission is the strongest form of proof. Sometimes, obtaining a written admission is the most efficient way forward. There is an important caveat though. If you carry on living with your spouse for more than 6 months after discovering the adultery, the court may say that you condoned it. And remember, only the innocent spouse can file on this ground. You cannot rely on your own adultery because of the emotional cost, financial cost, and difficulty of proving adultery. Many people end up using unreasonable behavior instead, which is what we will talk about next. Unreasonable behavior is the most common ground for divorce in Singapore because it covers a wide range of situations. The legal test is simple. Has your spouse behaved in a way that you cannot reasonably be expected to live with? Examples include physical or verbal abuse, constant criticism or emotional neglect, financial irresponsibility, refusing to contribute, excessive drinking, gambling, controlling, or obsessive behavior, sometimes repeated accusations, refusing intimacy without giving good reasons, or behavior towards children that makes the home life intolerable. Usually, you show a pattern of behavior, not just one isolated incident. And the behavior should be relatively recent, not something, for example, from 10 years ago. Documentation also matters, so you need to keep messages, emails, photos, medical reports, police reports, or even witness statements if they are available. The more contemporaneous the evidence, the stronger your case. If there is no fault and you have just simply lived apart, the next question is whether separation alone is enough, and that brings me to my next point. Yes, you can get divorced based solely on separation, even without your spouse's agreement. If you have lived separately and apart for at least 4 continuous years, the court will grant a divorce regardless of consent. You don't need to prove fault, you just need to show that you have been living separately, and separately means you have different addresses, and that's the easiest way to prove separation. But even if you live under one roof, you can still be separated if you have been living in separate bedrooms and you have kept separate finances, your routines are separate, and basically you function with each other as housemates, not spouses. The 4 years of separation must be continuous. Brief reconciliation attempts of less than 6 months will not reset the clock, but anything longer might. Now, this is one of the cleanest and most successful and less stressful routes to get a divorce, but it requires patience. If you have not lived apart for 4 years yet, then you may want to consider 3-year separation with your spouse's consent, and this is the next option for you. The difference between the two is simple. Consent. If you have been separated for 3 years, you can file for divorce, but only if your spouse agrees. If they do not consent, you must rely on other grounds such as unreasonable behavior, adultery, desertion, or wait until 4 years of separation have happened. 4-year separation does not require consent of your spouse, but after 4 years, the divorce cannot be blocked. 3-year separation is faster, but it's also riskier, as I've seen cases where a spouse first agrees, then later on withdraw consent when they realize that there are other financial implications they may not have thought about before. If you are close to hitting the 3-year separation mark, discuss this with your spouse, but if their cooperation is uncertain, then the safer route may be to plan around the 4-year ground. Now, let's talk about a less common but also important ground, desertion. Desertion requires showing that your spouse deserted you for 2 continuous years. You must prove 4 elements. Physical separation, that they left or refused to live with you. Number 2, the intention to desert, where they intended to end the marriage and not just take a temporary break from you. Number 3, there is no consent, that you did not agree to the separation. Number 4, no reasonable cause exists. In other words, they left without any justifiable reason. If your spouse had left for work overseas or left because of your unreasonable behavior, that might not necessarily be desertion. Evidence of desertion will include proof of when your spouse moved out, where they now live, and potentially communication showing that they have refused to return home to live with you. Because intention is hard to prove, many people don't rely on desertion. They prefer separation-based grounds because these are simpler and cleaner. Now, what if both parties agree not to blame each other at all? That's where a mutual agreement kind of divorce comes in. Yes, since the law changed, Singapore recognizes divorce by mutual agreement. It was introduced for couples who know that their marriage has come to an end and who do not want to blame each other and just move on with life. This path is meant for situations where both spouses accept that the marriage has broken down beyond repair. Instead of pointing fingers at each other, they calmly explain why, despite their attempts to reconcile, the relationship or marriage can no longer continue. This may include drifting apart over time, having different priorities, or just feeling that the marriage no longer works despite the parties' attempts to save it. The focus then shifts away from who is at fault and towards how both parties can separate and divorce with dignity. When handled properly, these cases usually fall under the simplified track, which means that the process is faster, less stressful, and more cost-effective for the parties. A divorce by mutual agreement works best when both spouses talk to each other, talk early, and if both spouses can be clear that the marriage is over, agree very early on that using this ground will be the best for both. Both parties also have to make some attempts at reconciliation, and also have a shared understanding on the ancillary matters such as children, finances, and assets. Once there is alignment, the paperwork and evidence can be prepared quite smoothly by the lawyers, which then brings us to the next question. Documentation is important and even essential, even in simple cases. Start with the basics. Things like your marriage certificates, identification documents, proof of residency, and your children's birth certificates. Then focus on evidence based on your chosen ground. For adultery, this will include photographs, videos, receipts, messages, social media postings, or even an admission by the spouse. For unreasonable behavior, you may want to keep incident logs, screenshots of messages, emails, medical reports, police reports, photos of injuries or damage, witness accounts, and financial records if these are relevant. For desertion, you want evidence of when your spouse left, their new address, and messages from them where they indicate clearly that they are not intending to return. For separation, you want to look at things like tenancy agreements, utility bills, letters sent to different addresses for both spouses, or evidence showing separate routines that both spouses have, even if it's under one roof. Even in uncontested divorces, preparing a clear evidential foundation gives you more control and reduces risk of delay. Now that you know what evidence together, the final step is to choose the most suitable ground based on your situation. When choosing a ground for divorce, I always ask clients 3 questions. First, what can we prove? If you cannot back up any serious allegations you make, it may be better to use a cleaner ground. Second, how cooperative is your spouse? If your spouse is open to working things out amicably, a mild unreasonable behavior petition or a separation ground for divorce may keep things peaceful. Third, what is your long-term goal? Some spouses want accountability, others want the fastest and least painful exit. The right ground depends on what matters most to you. Most uncontested divorces use very mild, unreasonable behavior particulars, or they proceed on separation because parties want to reduce conflict and simplify the divorce process. Now remember, the ground for divorce is just a doorway. The real impact comes later in children's matters, assets, and maintenance. But once you understand the 6 grounds and the rules behind them, you are already far better and equipped to plan your next steps. Yes, many people worry that they cannot proceed with divorce unless their spouse agrees to the allegations or admits fault. This is not correct. The legal test is whether you can prove one of the 6 grounds, not whether your spouse agrees with your narrative of the marriage. For example, in an unreasonable behavior case, the court does not need your spouse to concede wrongdoing. The question for the court is simply whether the behavior occurred and whether it is unreasonable to expect you to remain married. Even if your spouse denies everything, as long as your evidence is credible and the behavior meets the legal threshold, the court can still grant the divorce. Likewise, for separation-based grounds, the court primarily looks at dates, living arrangements, and evidence of parties' separate lives. There is no requirement for both parties to emotionally agree that the marriage is over. If anything, the court often expects that parties may disagree because that disagreement itself is part of the breakdown. The key is evidence, clarity, and consistency. Many marriages fail because of a combination of factors rather than one spouse's behavior. The law recognizes this. In fault-based grounds, like unreasonable behavior, the court is not making a moral judgment about who caused the marriage to fail. It is not saying one spouse is the bad guy. The test is objective. Did the behavior, whether intentional or not, reach a point where the applicant cannot reasonably be expected to stay married? Sometimes, both spouses have behaved poorly. Sometimes, both spouses have legitimate grievances. You are not required to prove that the other party was the sole cause of the breakdown. You only need to show that their action satisfies the legal threshold. That is why the divorce by mutual agreement ground has become very popular. It avoids the emotional minefield of assigning blame to either party. But even in a fault-based ground, the court's role is not to punish. The role of the court is simply to determine if the marriage is beyond repair and therefore a divorce should be granted. Legally, adultery requires physical intercourse. Emotional affairs, sexting, overly intimate messages, or inappropriate relationships, even if those are extremely hurtful, do not meet the definition of adultery. However, these conduct that I mentioned can still form the basis of unreasonable behavior. In fact, emotional infidelity is one of the most common unreasonable behavior allegations today that I've seen. Courts recognize that betrayal comes in many forms. If your spouse has formed an inappropriate emotional attachment with a third party, shared intimate messages with this person, or spent excessive and secretive time with this person, that can be strong evidence of unreasonable behavior. Many clients choose this route because unreasonable behavior does not require proving sexual intercourse with the third party, which, in getting the evidence, can be invasive and also difficult to prove. The focus is on how the conduct makes you feel and whether it makes continuing the marriage intolerable for you. The 3-year rule exists to prevent impulsive divorces, but the law allows early divorce if continuing the marriage would cause exceptional hardship or if the elder spouse has exceptionally unreasonable and depraved behavior. These are extremely high bars to prove. Courts rarely grant early divorce unless the facts are severe, such as repeated and serious violence, extreme psychological harm, sexual misconduct, or behavior that shocks the conscience. Ordinary marital affairs, incompatibility, or even mild unreasonable behavior do not qualify. The test is whether the harm suffered is significantly beyond what an ordinary spouse might experience in a troubled marriage. If you intend to pursue early divorce, you must present a strong, detailed set of evidence. In practice, most clients choose alternative solutions, such as going for counseling or entering a deed of separation, because applications under this part are exceptional and difficult and expensive. You can file for divorce, but practically speaking, your ability to stop the divorce by your spouse is quite limited. Now, Singapore law does not force someone to remain married if the other spouse proves one of the 6 grounds for divorce. A divorce is not about whether the marriage is worth saving. It is about whether the legal ground is met. The court does not require both parties to agree to end the marriage. If the applicant can prove the ground, such as separation, unreasonable behavior, or even adultery, the divorce will proceed. Objecting then often prolongs the process and increases costs without changing the eventual outcome. The law recognizes that a marriage requires 2 willing parties, and if one spouse is determined to leave, the court will not unnecessarily trap the other spouse in the marriage. No, establishing the ground for divorce is only stage 1, leading to an interim judgment. The marriage is not formally dissolved, but at stage 2, this is when the court looks at resolving the ancillary matters, such as the child issues, spousal and child maintenance, and division of matrimonial assets. This stage often takes months because the court must ensure fairness and the welfare of the children. Only after all ancillary matters are resolved will the court grant the final judgment, which then legally dissolves the marriage. Many people expect the marriage to be over immediately after proving the first ground, which is the ground for divorce, but the real work really happens in most cases in the ancillary stage. This is where parents have to face the financial realities and do financial planning, make parenting arrangements, and consider their asset divisions. Choosing the right ground can help to set the tone for the divorce, but the long-term consequences of the divorce really comes from how you handle stage 2 of the divorce. A divorce ends a valid marriage that has broken down. An annulment, on the other hand, declares that the marriage was never valid to begin with. Grounds for annulment include non-consummation of the marriage, lack of capacity, underage marriages, prohibited degrees of marriage, bigamy, or situations where consent was not properly obtained. If annulled, the marriage is treated as void from the start. Legally, it is treated as though the marriage never existed. Annulment is not about misconduct of either parties. It is about whether the marriage meets the legal requirements at the time it was formed. Some people think they can annul a marriage simply because it was short or unhappy. That is incorrect. Annulment is only possible in very narrow situations that are defined by law. If the marriage was valid and you want to end it, you have to seek a divorce instead. Thank you for watching. If you found this helpful, please like, share and subscribe so that you never miss an update in this video series. If you need guidance on your own situation, feel free to reach out. I'm Clement, a family lawyer in Singapore. You can contact me or read more of my articles through the links below, and you will also find my books and various other resources there. Follow for more. I'll see you in the next video.